Hello everyone, and welcome back to NeatLaw, your go-to channel for simplified legal concepts, exam-smart content, and practical insights into the world of law. Today, we're starting with a super important topic, internal aids to interpretation, Part 1. Now, have you ever asked, how do judges figure out what a law actually means? Well, before looking at outside sources like case law or dictionaries, courts first turn to what's already inside the statute, and that's where internal aids come in. In this video, we'll cover the basics, from titles and preambles, to headings, definitions, and provisos, all explained in a clear, exam-ready way. So grab your notes, and let's begin interpreting the law from within. Let's begin with the first internal aid, the title. Every statute has a short title, which is basically its official name, like, the Indian Contract Act, 1872. It helps us identify the act, but it doesn't really tell us much about its content or purpose. That's where the long title comes in. It explains what the act is about and gives a hint at its object and scope. For example, the long title of the Indian Contract Act says, "An act to define and amend the law relating to contracts." Now that gives us a clue, it's about both defining and modifying contract law. Next, we move to the preamble. The preamble of a statute outlines its underlying object, purpose, and philosophy. It can be referred to when a provision in the act is ambiguous or open to multiple interpretations. A relevant case here is KK Kochuni v. State of Madras, where the Supreme Court referred to the preamble of the Constitution to interpret the balance between fundamental rights and directive principles. Though not enforceable by itself, the preamble offers valuable guidance in statutory interpretation. Now, let us consider headings and marginal notes. Headings are placed before a group of sections and help in categorizing and organizing the provisions. They provide contextual understanding and indicate the general subject matter covered by the subsequent sections. Marginal notes, on the other hand, are brief summaries written in the margins beside the provisions. They are not part of the enacted law and are not legally binding, but they can serve as useful aids in interpretation. In the case of SS Railway Company v. Workers' Union, the court used the heading of a provision to assist in understanding the legislative intent, although with caution, since headings and marginal notes are not conclusive. Now we move to the definition or interpretation clauses. Most statutes include a dedicated section, usually Section 2, which defines key terms used throughout the Act. These clauses ensure clarity and consistency in the use of legal terms. For example, in Section 2(20) of the Companies Act, 2013, the term company is defined as a company incorporated under this Act or under any previous company law. This definition applies uniformly across all provisions where the term is used. It is important to remember that statutory definitions override ordinary meanings, and one must always consult the definition clause before interpreting any important term. Finally, we come to provisos. A proviso is a clause that typically begins with the phrase, "provided that," and is used to create exceptions, impose conditions, or limit the general operation of the main provision. For instance, if a provision states, "All shops shall remain closed on Sundays," and a proviso follows stating, "provided that medical shops may remain open," the main rule is that shops must remain closed, but the proviso carves out a specific exception. According to principles of interpretation, a proviso is to be read together with the main section. It cannot stand independently or override the primary provision. It acts as a limitation and not as an expansion. Where there is an apparent conflict between the main enactment and the proviso, both must be interpreted harmoniously. Some jurists, however, have argued that a proviso may reflect the legislature's most recent intention and, in certain cases, could be given precedence. To summarize what we have covered in Part 1 of Internal Aids to Interpretation. We began with the title, where the short title serves for identification, and the long title gives us insight into the object and scope of the statute. We then looked at the preamble, which, though not enforceable, helps us understand the intent and philosophy behind the law, especially when there is ambiguity. Next, we discussed headings and marginal notes. While not part of the enacted law, they assist in organizing the statute and can offer interpretive guidance when read with caution. We also examined definition or interpretation clauses, typically found in Section 2 of most statutes, which provide precise meanings to key terms, ensuring consistency and clarity throughout the Act. Finally, we studied provisos, which create exceptions or conditions to the main provision. A proviso must be read along with the main section, acts as a limitation, and cannot operate independently. Together, these internal aids serve as essential tools for interpreting statutes from within, ensuring that judges, lawyers, and students alike can better understand the law in its proper context. In Part 2, we'll explore the remaining internal aids to interpretation, including illustrations,